Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello everyone and welcome to the podcast. On this episode, we've got two cases for you with a privacy angle. The first is a Court of Appeal case about when employees may have to deliver up their personal mobile phones for disclosure purposes. And the second is an EAT case about covert surveillance in the workplace, with a twist in that case in that the surveillance was being carried out by the employee. I'm delighted this week to be joined by my partner in the employment group, Miriam Bruce, and Miriam is going to talk through the EAT case in a moment. But before that, we have Phones for You versus EE and others. The others in this case are a number of the large mobile phone companies. It's not an employment case, it's a competition claim by Phones for You, which went into administration a few years ago. Phones for You had agreements with various mobile network operators to supply their connections to retail customers. But during 2013 and 2014, those agreements expired or were not renewed. And in this litigation, Phones for You is alleging that that was a result of collusion between the various network operators, which amounted to anti-competitive behaviour. As part of the disclosure in the case, Phones for You wanted to obtain emails and messages which it believed were on the personal phones of the employees of the defendant companies. And so it was all about the scope of the disclosure obligations under the civil procedure rules, specifically Rule 31, which is the one which obliges the parties to give disclosure of documents that are in their control. The defendant phone companies argued that the court had no power to order disclosure of messages on their employees' personal phones because those phones were not in their control. They were not work phones, they were their personal phones. But the High Court judge disagreed and made an order that each defendant company had to make a request of the relevant employees to deliver up their personal phones to an IT consultant who would be engaged by the defendant company. Those IT consultants would search the phones for any work-related material, and that material would then be passed to the defendant employer to review for disclosure purposes. The phone companies appealed to the Court of Appeal against this order. They said that the judge could not order disclosure in the way he had because, as an employer, they had no right to require personal documents from their employees. They could only require documents that related to their business. So the documents in question were not in their control for the purposes of the disclosure rules. They said Phones for You could have made an application for specific disclosure or third-party disclosure, but that hadn't been done. This was simply about the basic disclosure obligations, and the judge had gone too far. But the Court of Appeal disagreed, and they upheld the judge's disclosure order. They said that the basic disclosure rules under CPR Part 31 simply require parties to litigation to make a reasonable search for documents, including adverse documents, and that was all the judge had ordered here. The relevant point, they said, was that the judge considered it reasonably possible that there were work-related messages on the employees' personal phones, and so a reasonable search should be made for those. They accepted that a third party, such as an employee, couldn't be compelled to disclose their personal documents or deliver up their phone. That could only be achieved through an order for third-party disclosure. But as a matter of principle, an employer could be required to ask its employees to make a search for relevant documents. Now, in terms of privacy, the court recognised that the employees' personal phones would comprise predominantly personal information, And so they said there was certainly a need to balance the disclosure requirements against the individual's rights to privacy. But they were satisfied on this aspect because, first of all, the searches would only be done if the employees consented. And secondly, there was a legitimate reason in that it was a search in order to comply with a legal obligation. And it was relevant here that although the majority of the material would be personal, the employees had, it seemed, chosen to use their personal phones for work-related matters. And the context of the case, of course, was an alleged covert agreement, a collusion between the defendant companies. And so the court was alive to the fact that the individuals involved may have deliberately avoided using their work devices to communicate with each other. So, although this is a competition case, you can see the same context extending to employment claims such as team moves or breach of covenant cases, where there is often an allegation that individual employees have colluded together and communicated outside of their work devices. And it's not difficult to see requests for personal phone searches becoming more common as part of the standard disclosure process, rather than perhaps expecting them to be made only as specific or third-party disclosure applications. So that's Phones for You versus EE. Turning now to our second case, which is also on the theme of privacy, but perhaps in a slightly more unusual way. And I'll hand over to Miriam now to talk about that one.
Thanks, Chris, and hi everyone. The case I'm going to be talking about today is the EAT decision in Northbay and Anderson. As with Chris's case, this also has a privacy angle to it. The key question the EAT grappled with here was whether an employer had fairly dismissed an employee for gross misconduct in circumstances where the employee had covertly installed a camera in his office at work whilst he was suspended. Now, I think most employers would think they're on pretty safe ground dismissing an employee where that employee had set up secret recording equipment at work. That's particularly so given recent case law has lent support to the view that covert surveillance by employees would generally amount to misconduct. However, as we'll see from the facts of this case, a more considered approach will sometimes be necessary, balancing workplace privacy rights with the employee's motivations for undertaking covert surveillance in the first place. Now, the facts of this case were as follows. The relationship between the claimant, Mr. Anderson, who was an employee and director of Northbay, and his fellow company directors had deteriorated. He had been suspended for alleged acts of misconduct, and whilst he was suspended, he became concerned that Northbay were trying to gain access to his computer, which was in his private office. So he set up a web-enabled camera in the office to monitor anyone who might be entering it and attempting to access his computer. At a point whilst he was off, the camera was moved, and as a consequence of this, Mr. Anderson told Northbay about the existence of the camera. Now, it was the employer's view that the covert surveillance was potentially unlawful, and they subsequently added this to the other misconduct charges against him. He ended up being dismissed, partly due to the covert surveillance, and he subsequently brought a claim for unfair dismissal. Now, Mr. Anderson succeeded in both the tribunal and the EAT in demonstrating that his dismissal was unfair. On the covert surveillance point, the EAT made some interesting observations. It was their view that in the context of a relationship which had broken down, Mr. Anderson's motivations for setting up the camera were key and had been improperly ignored by his employer in deciding whether he was guilty of gross misconduct. What the employer should have done here was to conduct a balancing exercise between the right to privacy of other staff and Mr. Anderson's concerns regarding alleged unauthorised access to his confidential information. They completely failed to do that, and as a result, the EAT was particularly critical of their approach. In particular, they noted that Northbay had failed to attach any weight to the fact that the camera was set up in an office to which Mr. Anderson had exclusive access, and not in an area generally accessed by the public. Northbay had also failed to take account of the fact that no one had been captured on the camera. In the EAT's view, these were highly relevant facts which tipped the balance in Mr. Anderson's favour, i.e. it was not reasonable to dismiss him on the grounds of covert surveillance given the context. I think this is an interesting case for a couple of reasons. First, most of the recent workplace surveillance cases have been about employers covertly recording employees. So this is notable as it's the employee carrying out covert surveillance on this occasion. Secondly, whilst at first blush it seems wrong that an employer would not be justified in dismissing someone for covert recording in the workplace, it's hard to disagree with the approach taken by the tribunal and the EAT here. As with most HR decisions, when considering gross misconduct dismissals, employers need to ensure they are acting reasonably at every step of the way. In particular, a reasonable employer should look at the context and motivations of an employee undertaking covert surveillance in the round and balance that against workplace privacy rights before coming to a decision. Finally, given advances in technology and remote working practices, it's become easier and easier for employees to conduct covert surveillance in relation to work matters. For example, recording formal meetings with HR is now pretty easy when you're conducting them virtually. Whilst this case demonstrates that employers would need to balance an individual's motivations for doing this against privacy rights of others, I think it would nonetheless be prudent to ensure your policies and handbooks make clear that covert surveillance is given as an example of gross misconduct. An express statement of this nature won't absolve an employer from carrying out a proper and considered disciplinary process, particularly a gross misconduct scenario, but I think it will help set the parameters of what constitutes reasonable conduct in the workplace and act as a helpful reference point in dealing with cases of covert surveillance by employees in the future. So that's the case of Northbay and Anderson. I'm going to hand back to Chris to bring today's podcast to a close.
Thanks, Miriam. A very interesting case there and very relevant in the current remote working environment that we are in now. I know from clients I speak to that there is often an uncertainty and a concern as to when video calls are being recorded. As Miriam says, I think a key point there is to have a clear policy about when calls are to be recorded and when they are not. So that's the end of the podcast. I do hope you found it useful, and as always, please do feel free to contact us with any questions or comments. And until next time, stay safe, stay well, and we look forward to speaking to you soon. Thanks very much.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.